Hello, everybody, and welcome to today's panel on DEI and the First Amendment. I'm Tonga Leslie, Director of Policy and Program for Racial Justice at ACS, and your host for today's event. As all of you are likely aware, the past 2 years have seen an unceasing onslaught on diversity, equity, and inclusion programs from right-wing operatives who are increasingly using the law to challenge DEI. We've seen President Trump issue executive orders in his first term and in this term, targeting quote unquote illegal DEI programs and censoring discussion of race and gender, as well as other issues, including accessibility across the government. Multiple states have now passed bans on DEI programs, and hundreds of private lawsuits have been filed challenging DEI programs in state and federal courts. Now, in the face of this constant barrage of lawsuits, new laws, new executive orders, we've seen a lot of institutions and a lot of people just back up and step down from diversity programs, close down their programs, become quieter about the work. But thankfully, we're also seeing a lot of advocates turning to the First Amendment to defend their programs. And in the past few months, we've seen them win some surprising victories. So today we're going to hear from advocates who have been using the First Amendment to defend DEI at all levels of the legal system. And we're hoping that this will inspire further action among you to see what ways there are that we can continue to resist and use the law to protect these vital programs. The first panelist we're going to hear from is Katie Euchre. She directs the Economic Justice Project at the Lawyers Committee for Civil Rights Under Law, and she was part of a challenge to the recent Trump executive order, which banned funding to organizations that engage in diversity and inclusion efforts. So welcome, Katie. Thanks so much for joining us. And I wonder if you can start by just telling us a little bit about your client and the kinds of programs that they run.
Sure. Thanks so much to ACS and Taonga for having me. And we're very happy to be on this panel with these great litigators. Yeah, Chicago Women in Trades has been around since the early 1980s, and they were established by a small group of women who were at the time seeking to enter into the skilled trades, construction trades. So if you think like mechanics, welders, carpenters, painters, and they faced multiple barriers to getting into those occupations, and they just they had to fight their way through and decided that they wanted to stand up a nonprofit to support women, and especially women of color, to access these professions that are much more accessible to people who aren't necessarily college educated, and that pay decent living wages and often come with benefits. And so they stood up the Chicago Women in Trades, and since then they have become a leader across the country in providing inclusive programming that's woman-centered to increase the representation of women in the skilled trades. And their services are used by employers, workforce boards, to recruit and retain women in these professions. Women today only represent about 4% of the skilled trades, and that's up from 2% just a few years ago. But there's much work to be done, and there's a huge demand for workers in these occupations right now. So they're a very popular program, but all of that work now is in jeopardy because of the anti-equity executive orders that Trump issued in his first 2 days in office.
Okay. Can you, it sounds like great work, and also when you double 2% and get to 4%, it sounds like we have a ways to go. Can you say a little bit more about the executive order and why that was a challenge for your organization? What was the effect that that was going to have on your client?
Yeah, so before the executive orders issued, we were tracking the private litigation that was that I know that Lawrence and others have been involved in, that was really trying to apply the sort of illogical reasoning from the Supreme Court decision and students for fair admissions to other sectors, including government contracting programs, private charitable grant making programs, employment programs. And so we started to see this trend of new lawsuits, and we were filing amicus briefs in those cases. Most of those cases were getting struck down on standing because many of them are manufactured cases on behalf of anti-civil rights groups like American Alliance for Equal Rights and Pacific Legal Foundation and others. But one case got the furthest, and that was the case against the Fearless Fund Foundation in Georgia. And in the materials, I actually included an amicus brief by Professor Roger Colenval, because he argues in that brief that charities have a First Amendment right to define their missions and donate as they see fit based on those missions as a form of expressive speech. So it was sort of one of the first places that we saw the First Amendment coming up in these cases. We knew that the Trump administration was going to accelerate these attacks. And indeed, on his very first day in office, he issued this executive order 14151, which is ending radical and wasteful government DEI programs and prefacing. And then the very next day, he issued EO 14173, ending illegal discrimination and restoring merit-based opportunity. And I'll drop those in the chat for the audience in a second. But the executive orders do a number of things, but the provisions that are particularly dangerous in terms of chilling First Amendment rights are two provisions in particular. One that calls for the termination of all equity-related grants across all federal agencies and equity-related contracts. And another provision that requires federal contractors and grantees as a term of their grant agreements or contracts to certify that they do not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. Now, these provisions are within the executive orders that talk about DEI as broadly illegal and immoral, and also talk about equity as shameful discrimination. And so these provisions are put in there sort of with the very, I think, obvious effect or intended effect of chilling speech, and that has been the result. So we actually at the Lawyers Committee for the last couple of years, in the wake of the Supreme Court's Students for Fair Admissions decision, stood up a direct service clinic for nonprofits to advise them, provide strategic advice about their racial equity programs and compliance with the law. Because we were already, even before the Trump administration, seeing the chilling effect that these lawsuits were having on nonprofits' lawful activities. But after these EOs, these executive orders were issued, you can imagine that we saw an incredible increase in demand for our services, and folks thinking that their very mission, their very utterance of terms like race and discrimination and diversity was going to draw the ire of agencies and the administration, even for purely privately funded activity. So we decided that our client felt very strongly that they felt that they needed to challenge those orders in order to ensure that they could continue their work, but also that women could continue to get hired into these skilled construction trades across the country. So that's where we are today.
I thank you for laying that out. I want to ask you in particular. So there's parts of this executive order that are saying the government will not fund certain activities, and it seems like there's some argument on that, but it seems like it's closer to the line of courts being saying, okay, well, this is government funded speech. But there's also a provision where they have to certify that they're not engaged in illegal DEI. And a lot of the language that's been thrown around generally by the administration is, well, we're going after these illegal DEI programs. Why shouldn't you certify that you're not doing illegal DEI? Can you speak to that a little bit and um, how you grappled with that in this case?
Yeah, so there's a little bit to unpack there. First, it's true that under Supreme Court precedent, namely Rust versus Sullivan, that the government does have wide latitude in making funding decisions. And there are a line of cases that say, the government can decide not to fund something without necessarily violating the First Amendment. And the problem, though, with that is that the government also cannot decide to defund a program because of its First Amendment protected speech, right? Because of engaging in protected activity. And so with respect to the provision of the executive orders that calls for the defunding of all equity-related grants, the argument in some courts that have been successful is that is a funding decision or a defunding decision being made because of someone's protected speech. And there, so there's a number of lawsuits that are challenging these executive orders. Ours in Chicago is one of 4 cases that challenge the orders on First Amendment grounds. And the case that was filed out in the Northern District of California, San Francisco AIDS Foundation versus Trump, the district court, Judge Tiger, has a great opinion on why and how that equity grant termination provision, the funding termination provision, violates the First Amendment, because here it's not just that they're deciding to fund some things and not the other, that instead they're withholding benefits for anything that's related to sort of this dangerous idea that the government has defined as disfavored speech, which is anything that's equity related. So that's with respect to the funding decisions. The certification provision, you're right, is different. That's the provision that requires grantees and contractors to certify that they're not engaging in any program that is promoting DEI. And then it says in a way that violates the anti-discrimination laws. And our district court preliminary injunction order, which was granted on this issue, the court relied on the Supreme Court case of the name is escaping right now, but it's the AIDS,
Edinburgh, maybe?
No, not that, not Umberg, but it's the one that has to do with foreign aid. I'll put it in the chat in a second, but essentially that you can't use government funding to restrict speech beyond the program itself, right? So because the executive order on its face, the certification provision, it touches on activity outside of the federally funded grant program, that it violates on its face this what under the doctrine of unconstitutional conditions. So that's one reason why it violates the First Amendment, but there are a number of other reasons that the certification provision does violate it, notwithstanding the fact that the government is now attempting to cabinet to, only unlawful DEI, right? Whatever that means. And the other reason is that it's pretty clearly and expressly viewpoint specific discrimination, because the provision itself on its face says, that it only affects programs promoting DEI while not doing anything or subjecting programs to additional scrutiny that oppose DEI. So it's pretty much on its face expressly discriminatory in that way. But also when you take the provision in the context of what the rest of the executive order says and the way that the agencies have interpreted it through their implementation, there's tons of evidence that show that whatever the administration means by illegal DEI is different now than it was before the executive orders were issued, right? So we know that they're censoring speech. They're censoring the very words DEI. And so there is a Supreme Court case, Forsyth, that says that courts are supposed to look to agencies, the enforcement agencies' interpretation of the statutes that are being challenged when looking at these sorts of violations. And in context, you can, our court in Chicago was comfortable finding that these executive orders are trying to affect speech in a way that was not cabined, like the government is now arguing as a result of this litigation.
This is fabulous. And you've laid out a lot of themes that we are seeing across this litigation. I want to bring in Larry. Larry Lustberg directs and has directed for several years the Fellowship in Public Interest and Constitutional Law at Gibbons. But he had a different posture on his case because even before this current administration, there's been tons of private suits. And your firm was involved in the defense of the New Jersey State Bar Association's diversity program, actually in the face of a private lawsuit that was trying to dismantle it. Can you say a little bit about, the program in question? What was that program, and what was the challenge trying to do?
Sure. Thanks, Tonga. And it's great to be with you all today. I'm honored to be speaking and anything having to do with ACS. And I like when you said that I've been directing this for several years, since it's been 35. But it makes me feel younger when you say several. Anyway, we were asked to represent the New Jersey State Bar Association in a challenge to its affirmative action program. That affirmative action program was essentially a set-aside type program. So certain seats on the very large board of trustees of the New Jersey State Bar Association were reserved for attorneys of color. Let me see if I can increase that volume. I told you this would happen. Any better?
I think that's a little better.
Okay, sorry, this does happen. So the State Bar Association has approximately 50 members of its board of trustees. For years and years and years, that board of trustees was, not surprisingly, dominated by white men. Beginning in the 1980s, the Bar Association took particular steps to diversify the leadership of the Bar Association. It began by setting aside 3 seats for attorneys of color. It was Asian American, or Asian Pacific, African American, and Latino attorneys. Later on, it was expanded to 5 seats, and it included an LGBT representative, and women. And over the years, the result has been extraordinary. When I go make presentation to the Bar Association, I'm in a room that is truly diverse, and it's a wonderful thing. The diversity program still allows for almost every seat on the Bar Association to be available to anybody. And in fact, the program expanded to include membership in diversity bar associations. And if you read the opinion, which I know is in people's materials, you can see I'm not going to list them, the many diversity bar associations that membership of which allows you to run for certain designated seats on the board. But at the end of the day, what this was a program that essentially required that certain seats be occupied by people in what had been traditionally underrepresented groups on the Bar Association board. That was the program that came under challenge. And I can tell you a little bit about the strategy that we pursued if you want. Because initially my reaction was to full-throatedly attempt to defend following SFFA an affirmative action program. To me, this was an opportunity to um, to to really take on the application of students for fair admissions in what it was the kind of Title VII context. Let me just explain that quickly. The claim that had been brought by the plaintiff was under the New Jersey law against discrimination. The New Jersey law against discrimination essentially uses the same analysis as Title VII. And Title VII does, as we sit here today, still allow for affirmative action programs under certain circumstances, which I'm sure many people who are listening in know even better than I do. Those circumstances which are set forth primarily in the Supreme Court decisions in Weber and Johnson, which I'm sure many people are familiar with, basically says that in a situation where you're remedying a manifest imbalance based upon traditionally segregated criteria or categories, that's one time when affirmative action programs are appropriate, and the other is in a situation where where the non-beneficiaries of the program are having their right. The language of the cases is that the program cannot unnecessarily trammel the rights of non-beneficiaries. We felt strongly that both of those two criteria were satisfied here. That that this was, as I mentioned earlier, a program that was specifically designed to remedy a manifest disproportion from many, many past years. And it was also one that did not unnecessarily trammel the rights of non-beneficiaries, because there were all these other seats that one, like such as the plaintiff here, could have, if he wished, applied for and be on the board. In fact, this particular plaintiff had been on the board at one point. It was particularly true because, as I mentioned, a number of the seats that had been set aside for this purpose were allocated to diversity bar associations, and most, if not all, actually, of those diversity bar associations allow people of anybody to join them and could qualify for those seats. So it really was, in some ways, a very modest affirmative action program, and we defended it accordingly. However, that's not what we're here to talk about today.
Yeah.
Um,
Well, I'm glad
yeah,
you set that out, and I want to just point out, you said, as Katie said, the language often talks about traditionally underrepresented or historically underrepresented, but I'm aware of at least the last legal statistics I've seen, and lawyers of color remain underrepresented. I think women lawyers remain underrepresented. So this also is a very current concern. But I do want to shift, as you're about to, into the legal strategy,
yeah,
because yeah, you took an interesting turn there.
yeah, and I have to say that I took this case after it had been lost at the trial level, so I took it on appeal. And some of the groundwork for this had been laid by my predecessors who had raised this First Amendment issue. And to be clear what the First Amendment issue is, and I feel really strongly about it for reasons I'll get into in a second, that have to do with taking what I view as precedent that is unfavorable, even odious to me, and turning it to our advantage. And that was the case here. Um, there had been a case in the New Jersey Supreme Court that then went to the U.S. Supreme Court called Dale, with which I'm sure many people are familiar. Dale was a case where the Supreme Court of the United States held that it was okay for the Boy Scouts to expel a scout leader because he was gay. And that the reason that was okay was because the Boy Scouts had the right to associate with whomever they wished as a matter of their own free expression. That is, what the United States Supreme Court held was that the state of New Jersey, which is where Dale came from, couldn't force the Boy Scouts to send a message that the Boy Scouts accepted, this is their language, homosexual conduct.
that the Boy Scouts had a right to oppose or disfavor homosexual conduct, and so they had every right, therefore, to expel Mr. Dale. As I said, honestly, for me, that decision is one that I just hated at the time. I wasn't actually really involved in the case. I hated it because I thought it understated the state's interest in non-discrimination. I hated it because I thought it overstated the Boy Scouts' actual views, which really were in many ways favorable to diversity. And I hated it because it was really brutal to James Dale, who it was, tortured by it. I've come to know Mr. Dale actually as a result of all of this. He's an extraordinary guy and was a courageous plaintiff. But because I'm a lawyer, and although this is increasingly not the case, I really do believe in the rule of law. And so I thought it was my job to take a decision like that and make it work for us. And that's really, I think, in some ways what we're here to talk about today, how that kind of First Amendment doctrine upon which Dale relied is something that we can rely on now in defending DEI programs like the State Bar Association's affirmative action program. So that is, Tanya, if the rule of law is that courts are supposed to defer to private associations regarding what impairs their expression, and that's what the court held in Dale, then that should also apply to the New Jersey State Bar Association's very strong belief, which the record showed, in the value of diversity. And just as much as it applies to the Boy Scouts, really much weaker expression of abhorrence for homosexuality. If the rule of law is that the Boy Scouts could not be precluded from excluding Jim Dale, then how could the New Jersey State Bar Association be precluded from associating with and including those who it wished to associate with and include? And that was, in essence, what my goal was. And I thought it was a goal that was tactically wise, because I think we all see a court system that's increasingly conservative, that at least in the LGBT context, but in others, hands down decisions with which we might feel strongly, which we might strongly disagree, but can be used by virtue of their language, by virtue of their reasoning, to accomplish our own goals that are much more beneficial. And so, what I really set out to do was to create a record that would be attractive, not only if we went the affirmative action route to more liberal judges, but would also appeal to more conservative justices in the New Jersey Supreme Court, who, by the way, recently denied certification in the case, which is like certiorari in the U.S. Supreme Court. So this is a win. We're there, but we may yet face a federal lawsuit. It allowed us to kind of appeal to both sides of the political spectrum. And to me, it's a lesson. We progressive lawyers, really need to learn to take the precedents that come out of a court that we might disagree with a lot and use them for our own benefit. And that, to me, is the real lesson of the Saadeh case in New Jersey.
Brilliant. I thank you so much. Appreciate it. You bring that lesson. We are going to move to our third panelist. Before we do, we're about halfway through the program, so I want to give you your first CLE word. You can find the documentation on the ACS website where you registered for this event, and that word is emerald. Once again, that word is emerald. You can also start to submit questions through the chat, and I'll try to loop those in, and then hopefully we'll get to some time for audience Q&A at the end as well. But before all that, I want to turn it to Rob. Rob McDuff is with the Mississippi Center for Justice. We've seen Illinois, New Jersey, and now we are going down south. And you were actually facing a state ban from the Mississippi legislature that was trying to control what concepts could be discussed at the both in the public schools as well as in the colleges there. I was curious if you could lay us a little bit of background on what the law was and who were the plaintiffs that you were working with who were affected by that.
Sure. Thank you for having me. The Mississippi was one of many states that sort of joined the anti-DEI bandwagon. Some passing laws prior to Trump taking office for the second time and promulgating these executive orders, and then some in the wake of that. Certainly Mississippi, in its lurch to join the anti-DEI bandwagon in 2025, adopted one of these. And a feature of many of these laws is a prohibition on discussing certain, quote, divisive concepts, end quote, that, and the motivation being that the sort of counteracting the myth that white students in public schools, K through 12, and in colleges and universities were somehow being made to feel guilty because they were white. And Mississippi adopted that same prohibition on divisive concepts, but it went even a step further by including in its anti-DEI free speech restrictions a provision that prohibited schools from, quote, engagement, end quote, in any, quote, formal or informal education designed to increase awareness and understanding of issues related to race, sex, color, gender identity, sexual orientation, and national origin. And I mean, if you think about that, that provision, if literally enforced, would mean that history teachers couldn't teach about slavery, couldn't teach about the Civil War, couldn't teach about Reconstruction, couldn't teach about the Civil Rights Movement, couldn't teach about the women's rights movement, women's suffrage, couldn't teach about the LGBT plus rights movement, couldn't teach about discrimination, historical and present day discrimination in a wide array of fronts. And you would literally you'd have to change the history courses. You couldn't discuss differences in sex and treatment based on sex in, say, a family law course or a biology course or sociology course. It really would radically transform education at all levels. And during our hearing on the motion for preliminary injunction, we had a witness who was a law school professor in college. And the federal district judge asked him, he said, under this law, could you teach about Korematsu versus United States? No, we couldn't. Could you teach about the Dred Scott decision? No, we couldn't. Could you teach about the 13th, 14th, and 15th Amendments? No, we couldn't. And the sheer breadth of that, the attempt to sort of erase history, led to the judge striking down that provision on First Amendment grounds. But the Mississippi statute also contained a prohibition on these 8 divisive concepts. And I'm not going to take the time to read them all, but I'll give a couple of examples. In each of these divisive concepts is presented as a prohibited statement of fact. And so the first one, or a prohibited viewpoint, the first one is meritocracy or traits such as hard work ethic are racist or sexist. And, certainly they've been used, and meritocracy's been used in a racist or sexist manner over the years in terms of discrimination in employment at a wide variety of levels. But under a little reading of the Mississippi statute, which prohibits engagement with that, you couldn't even talk about it in terms of the use of meritocracy. Another one was an individual by virtue of his or her race, sex, color, national origin is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Now that, read literally, would prohibit discussion of the phenomenon of implicit bias in sociology class, psychology class, so forth and so on. So these laws were also struck down. These concepts were also struck down in our case on the grounds of also First Amendment grounds, but more importantly, vagueness grounds. And similar law in Florida, which included the 8 divisive concepts, was struck down on vagueness grounds. That's now an appeal to the 11th Circuit. A law in New Hampshire that had 4 divisive concepts was struck down on vagueness grounds. That's on appeal to the First Circuit. One in Oklahoma, I think 2 or 3 of the 8 were struck down. That's on appeal. There's an Alabama statute that wasn't quite as strict in terms of it still allowed discussion of these concepts as historical or present day phenomenon. You just couldn't require endorsement of them. It was upheld by a federal district judge very recently in Alabama on the grounds that this was government speech. Now, in our case in Mississippi, we relied on, in an era when precedent doesn't mean much, we relied on, for example, Tinker versus Des Moines Independent School District from 1971, where the Supreme Court said students and teachers do not shed their rights at the schoolhouse gate, where the kids were sent home because they were wearing a black armband in protest against the Vietnam War, and they were kicked out of school and sent home. And the Supreme Court reversed that, and we said, you just as you can't prohibit people from wearing a black armband, you can't prohibit them from talking during class in an appropriate course about race discrimination or sex discrimination. And that case, Tinker versus Des Moines Independent School District, was recently reaffirmed by the Supreme Court in the Bremerton case about the high school teacher who prayed on the 50-yard line and had been disciplined for it. And the Supreme Court reversed it and said, no, he had the right to do that after school football games. So these 2 decisions that I mentioned a minute ago, the one from Alabama, and then there was one by the 8th Circuit in a very narrow case from Arkansas involving a statute that prohibited certain forms of discussion about critical race theory in K through 12 schools. Both of those courts said this is government speech, and the government, even though it's in the classroom, the government can require adherence to its preferred view on these issues, and they're not subject to review on the First Amendment. Well, that's a pretty radical thing. And I think we're going to be seeing that doctrine fought over and fought about in these various appeals, including the appeal of our case, which the state of Mississippi has appealed to the 5th Circuit. And I think we're going to see a lot of this play out is to in this crucial area in public schools about how we discuss these issues, including race and so many others. Are we going to turn the clock back to a time when people didn't really talk about them because discrimination was not considered something that should be discussed in the public schools? Or it just wasn't, because it wasn't on the radar in so many places. Or are we going to allow people to teach as they were teaching prior to this sort of anti-DEI craze that's going on that really has led to a restriction of free speech in so many areas? And it's going to be interesting, but hopefully the courts uphold some semblance of the First Amendment precedent that has existed thus far, and that we're able to, there's so many pernicious aspects of the anti-DEI movement, but hopefully on the front of public education, we can sort of hold the ground so that it doesn't move forward in such a negative way.
That's great. Appreciate your work in Mississippi and glad that it's prevailed, at least thus far. I want to kind of bring us all into conversation. I think one of the themes that seems to come up in these conversations with the First Amendment and DEI is, what do we do with these maybe negative or harmful precedents from the past. Like we've definitely seen the First Amendment be weaponized in cases like Masterpiece, in cases like 303 Creative, in the school prayer case, in a way that has not always been inclusive. And at the same time, it's set out these recent Supreme Court precedents that kind of lie there, potentially waiting as weapons to be used in defense of diversity programs. So I'm curious how you all have thought of that. If there were there parts of precedents that you're like, oh, this could be useful, but I think it's too dangerous to reaffirm it. Were there things that you found surprisingly useful in looking through some of that jurisprudence?
Well, I mean, I think I'll take a shot at that, Tonga. I mean, obviously, that's kind of what I was talking about. I mean, to my mind, I think we're hiding our head in the sand if we think that these decisions, these kinds of decisions like Masterpiece Cake Shop, like I talked about Dale, those kinds of cases are not here to stay. I think it's our job as progressive lawyers to take those precedents and do what we can with them. And for better or for worse, and let me be clear, I think it's overwhelmingly for worse, because I think First Amendment doctrine could stand on its own without it. They do reinforce certain First Amendment rights. And I don't discount the possibility that the Supreme Court would attempt to distinguish our DEI related cases from cases which invoke First Amendment rights that are more centered on religious belief. But I think we have the responsibility to argue that the First Amendment is the First Amendment. And if the Boy Scouts can exclude Jim Dale, then the Bar Association of New Jersey can include those whom it wishes to, and actually exclude others. So I think it's our job every single time in a system of laws to try to take the pronouncements of those laws and use them to our advantage. I think what this panel has in common is doing exactly that, taking First Amendment principles that so far are holding up, and applying them in the DEI context, even as the Supreme Court turns against DEI in cases like SFFA. That's our job. That's our mission. And I think, if there's something I would want people to take away from this, is that so long as we are a society of laws, and who knows how much longer that'll be, but at least so far, it's our job to use those laws to our advantage. And I don't mean to our advantage in some horrible adversarial way. DEI is a good thing, and it's our job to use those principles to vindicate that sort of interest.
Thank you. Rob, Katie, do you have perspectives on this?
Well, I'll just have to say, when I was looking, as we were preparing our briefs in the Mississippi case, and obviously I went back to the Tinker case, which is a classic of First Amendment as applied to the public schools. But I found reread the Bremerton case, which had a result that I didn't necessarily agree with, that it was that the high school teacher could come out there and hold prayers on the 50-yard line at the end of the game. But I was heartened by the fact that Justice Gorsuch had cited the Tinker case and quoted the key principle that we were relying on. And so, it's important to be able to show the courts that even in this day and age, with the sort of the lopsided Supreme Court, that some principles are still cited and hopefully will remain true and remain in the long run, remain steady.
Yeah, I mean, the First Amendment has been used by opponents of civil rights for decades, going back to the enactment of the Civil Rights Act of 1964, to claim that it was an unlawful regulation of private speech. And in those early cases, the courts upheld the civil rights laws, saying that they're not content specific, they're not viewpoint discrimination, that they only forbid speech that rises to the objective level of becoming unlawful conduct, right? And I think those we continue to see the First Amendment being used as both a sword and a shield, and it is very problematic because sometimes these cases may provide short-term gain, but in the long run may be actually taking more away from the communities that truly benefit, or that primarily rely on the anti-discrimination laws. So it is a very fraught area.
I also wanted to, look to you. We're looking at timeless principles, but also specific factual dynamics that underlie these laws. And it's always interesting pivoting from number one, the opinion, to the briefing, to what we know to be going on in the world, and the political context of animus, of sometimes a very explicit desire to stamp out a certain point of view that we'll see behind things. I'm curious how folks have handled that before your perspective, judges. Was there receptivity to the factual context, the sort of intent behind things? Was that something that judges didn't want to get into? And sort of how do you manage that in a context where sometimes the law wants to be very clean and neutral and divorced from political context, but political context is driving a lot of these decisions? I might go to you first, Rob, because I imagine often in Mississippi, the difference between what people are trying to do and what they say they're trying to do is large.
Yeah, well, I mean, in Mississippi, we have a backdrop that many southern states have of the rewriting of history after the Reconstruction era, when the former Confederates who held on to power despite the black vote and the Reconstruction, and then led the move to disenfranchise the newly franchised former slaves who were able to vote, and elected many black office holders. And in the course of pushing back and eliminating their political power completely, there was this whole myth, this historical myth of the lost cause that was born. And it was really an honorable cause of the Confederacy, they said. And monuments sprang up to Federal soldiers and Confederate soldiers and Confederate generals and the wives who had sustained them back home. And you still see these monuments spread around courthouses, county courthouses throughout the South. Some were taken down in the wake of the George Floyd murders, but not many. And so they're still there. And now we're seeing, with Trump's attack on Trump and the attacks of so many others on DEI, another effort to rewrite history, so that it's not the Black and brown people and the women and LGBT people and trans people who are victims, but it's the white people who are victims. And we've got to protect them from feeling guilty. And that's why so many of these laws are being passed. And it's an unfortunate twist and turn on history. It proves the point in some sense that victors write the history. In this case, victors in elections are writing the history, or political parties that have a predominance of power. And we're seeing that in Mississippi, but we're seeing it nationally as well. And that's why I think it's really important, given how, I mean, the attack on the public schools and what can be taught in the public schools is particularly pernicious, because that's where so many people learn about history and learn about all of these important subjects. And if they're going to be getting this dose of anti-DEI, this warped dose of anti-DEI reality, it's gonna really be infectious. And I think it's no accident that the current administration is focusing on public schools, and that they are focusing on colleges and universities, because of the importance of having an open-minded, free education where people can learn about different things and different realities. And unfortunately, anti-DEI is part of a movement to restrict that, and to channel sort of the speech that the current administration wants to enforce and the values it wants to enforce.
I want to also turn to you, Katie. How much were you trying to look behind the face of these executive orders, and how much was your judge willing to do that?
Yeah, in the various cases challenging these executive orders, the courts have come out differently with respect to different provisions. And the certification provision, the one that requires grantees to certify they're not operating any programs promoting DEI that violate anti-discrimination laws, our court in the Northern District of Illinois held that was a violation of the First Amendment, notwithstanding that language that it's supposedly cabined to unlawful activity. But other courts came to a different result, saying that, well, the certification is only asking grantees to certify they're not violating any anti-discrimination laws. But our court looked at the rest of the executive order and the way it had been implemented and said, the thrust here is that the government's view of what is illegal has changed with this new administration. And that case is Forsyth County versus Nationalist Movement, Supreme Court case from 1992 that says, courts shall look at the authoritative constructions of the ordinance by the enforcement agency in its own implementation and interpretation of it. And as I said, I think across these cases challenging the EOs, there is ample evidence to show that the DOJ, right, and which has come out and said subsequent to these executive orders that all DEI is unlawful. I mean, they've said that. And they've, these agencies that are censoring words, right? Not taking a look at whether the underlying program is doing anything at all, but simply the utterance of the words, and looking at the depiction of DEI by this administration repeatedly as something that is shameful, immoral. That is pretty quintessential viewpoint discrimination that is targeting, what the administration considers dangerous thought or disfavored speech. So it's an issue that's currently on appeal in our case at the Seventh Circuit and in a case brought by National Association of Diversity Officers in Higher Education in the Fourth Circuit. So stay tuned on how that issue gets resolved.
Thank you so much. We're keeping it open for the Q&A. Feel free to either put your question in the chat or you can raise your hand. Hopefully we can get to a couple of those. I'm also going to give you the next CLE word. The next CLE word is sapphire. So first code was emerald, second code is sapphire. We've got a quick one, which hopefully Rob has the context on, asking if you can comment on the Mississippi IHE to stop distributing student activity fees to student organizations, citing HB 1193.
Yeah, I mean, one of the things we were concerned about, and we actually put on evidence related to this, is the impact this law might have on student organizations who, one of our plaintiffs was a Women in Science and Engineering. One of our plaintiffs was an LGBTQ plus student group. They were at different universities in the state, and we were concerned that organizations like that, organizations like the Black Student Union, Black Student Association, might have their funding cut because they were professing ideas. They were focusing on, race, sex, sexual orientation, and the other prohibited provisions. That hasn't happened in light of the injunction, but what we have seen the universities do, at least at some universities, is just change the whole student activity, student organization funding formula so that certain funds are not given to any of the organizations, but they're instead spent on other student activities. So we're still sort of looking at, I mean, if they were doing it, if they were taking money away from some organizations and not others, that would clearly be a problem under the First Amendment. Here, they're basically saying we're not going to give it directly or give as much directly to organizations as before. And we are honestly, we're looking at that now to see whether we think it violates the injunction and what should be done about it.
Tonga, you're mute.
Question is about the broadening definition of Antifa and related activities, new orders coming out and related to that, and who's going to be put on the terrorist watch list and monitoring. That is a big one, and maybe it needs a whole program, but does anybody feel?
Sorry, you were mute for some of it, so I kind of missed some of the question.
Yes. This question is about if anybody can speak to the new executive orders and guidance around Antifa related activities that can put folks on the terrorist watch list, and how that can suppress trans rights, DEI rights.
I mean, what I can say is that we're all becoming First Amendment lawyers under this administration, whether we want to or not. And if you want to plug in and get involved, reach out to any one of us, right? Because there are First Amendment violations happening at breakneck speed under this administration, and I think we're going to see multiple challenges around this newest, the executive order that was issued late last week. Trying to designate an ideology as a terrorist organization. So there are just all kinds of things to say about that, but I would just say there's really a challenge for everyone here, or in some cases, many challenges.
I'd also like to add one thing, which is that's 100% true. We all have to become First Amendment lawyers. And in some ways, the reason for that is that's the lowest hanging fruit for all of us. I mean, these are obviously, as Katie has said, as Rob has said, these are obviously content-based restrictions. I mean, people are being targeted in one way or the other because of what they say and what they believe. But let's also not ever lose sight of what's beneath it. Which is there are equal protection arguments here. Who is targeted does depend on race, ethnicity, and lots of stuff that's lurking beneath the surface, and honestly, in many cases, not very far at all. And so I think I think we all have to keep our eye on the ball of the fact that the First Amendment is an incredibly important tool, really, as Katie has just said, with regard to this administration's actions, because it's kind of easy. I mean, we may not win, but we're so clearly right. But lurking beneath it is racism, is homophobia, is Islamophobia, and is lots of other of equal protection violations that I think we have the obligation to ferret out, even if they don't ultimately become our legal theories or the basis for our victories.
That is great. And appreciate all of you so much. I would also underline that beyond all the theories and the wrongness that was underlying these cases, it needed somebody to bring them. So I thank each and every one of you for bringing them and for talking to us about it. We'd love to see more folks in our network bring these. I encourage folks to check out the program guide, which this year we focused on First Amendment across the administration's activities. There's a lot to dig into. You also might want to check out our recent program, which was the SCOTUS preview. We've done both a live event and a podcast on that. And you can feel free to reach out directly as well. If there's stuff that came out from this that would be useful, I think the attendees will probably be able to connect with you about that. We will send out the recording in a follow-up email, and it'll also be online eventually, so you can share that with your networks. And thanks to the attendees as well. Have a great rest of your afternoon and enjoy.
Thank you, Tonga.